events of the 4th World Congress on Adult Guardianship. I thank Peter Winterstein, Volker Lipp, and Dagmar Brosei for the invitation to this important event, an invitation which I gladly accepted. I start in English because I want to explain that I will talk in German. Because it is one of the few occasions that I can talk about the right to be equally recognized as a person before the law in my mother tongue. I hope you understand. Dem Thema meines Vortrags möchte ich mich
I will approach the topic of my presentation in 4 steps. As an introductory comment, I will talk about the role of human rights sources in law, and secondly, I address the human rights model of handicaps and shed light on its impacts on discrimination, autonomy, and solidarity. Number 3, discuss the right for people to be recognized as a human right. And number 4, I address the implementation of Article 12 of the CRPD, the Convention on the Rights of Persons with Disabilities, in the law and in practice. I will also look at other questions if I have the time. Point 1, the role of human rights sources in law. The UN Convention, in many respects, is a further development of international human rights protection. The CRPD is among the modern sources of international law, where national monitoring was introduced as a new instrument of implementing and monitoring human rights. The European Union, for the first time, as a regional organization, could accede a human rights convention and has been a member since 2010. There are many other examples. The list of innovations is long that go hand in hand with the CRPD, the Convention on the Rights of Persons with Disabilities. That's quite a considerable list. For time reasons, I cannot address all of them. But that the CRPD has changed national and international law and sets new reform tasks is small wonder. Looking ahead, the vision into the future, that is the purpose of the standard of any human rights convention. If nothing were to be changed, there would need to be a new pact. Human rights are the normative response to collective experience of injustice. And collective experience of injustice to overcome, it takes standards, it takes values to transcend what exists. It takes subjective rights to enable the vulnerable people to defend their human dignity as people. Human rights sources always serve social transformation. They always presuppose a social change of awareness and should kick off further measures. This clearly shows, as is shown by the history of international human rights in the United Nations. For instance, the Anti-Racism Convention came about through the process of decolonization in the 1960s. And it promoted coming to terms with racism worldwide and tackling racism. With the Women's Rights Convention, the International Women's Movement took gender equality into the international and the national policy making. With the Children's Convention, overcome ideas of parental custody were questioned, and the Human Rights Convention in particular, that was passed at the end of the 20th century, took more and more differentiated individual groups of people into the focus. That process is termed pluralization or also personification of human rights in international law. Behind it is the finding that the parents of the General Declaration of Human Rights of 1948 only had a very one-dimensional picture of humans as a subject of law. You might also say the prototype of the legal subject was the white, healthy European man. Life situations of people of color, of ethnical descent, of women, of children were not thought along with it. Human rights were Eurocentrist male rights. Only the various social movements have changed this understanding of human rights. By means of the UN Convention on Disabilities Rights, the movement has fought a place at the table. The question of people with disabilities was taken out of the one-way road of welfare and prosperity. Second point, the UN CRPD is to replace the medical model of disability by a human rights model of disability. What's hidden behind it? There's more than just criticizing medicine or criticizing therapy or rehabilitation. On top of the critique regarding the medical model of disability as a one-dimensional, essentialist curtailment of impaired people and their deficit in health, the human rights model of disabilities aims at a new understanding of the fundamental concepts such as discrimination, autonomy, and solidarity. The term discrimination of international law is expanded by the CRPD. Discrimination is not just any distinction, exclusion, or restriction based on disability, which aims on or which has a consequence that human rights are impaired or refuted. Also, the so-called denial of adequate accommodation is a discrimination because of a disadvantage or a disability. This is the refusal of removing barriers, be they physical or communicative. Access here, there are no sign language interpreters here. That fact excludes people without hearing. The fact that there are no captioners erects barriers for people who rely on being able to read in order to understand. This likewise applies to translation into easy language. Refusing adequate accommodation is a new form of discrimination. Codifying that means to have a concept of equality which looks at the needs of all people or with people of like needs in the planning, and that needs to be heeded in distributing resources. The concept of autonomy is also changed by the CRPD. Autonomy not only means the freedom for some people who are mainstream. Autonomy within the meaning of the convention does not only mean the right to be left alone, to have autark, private, personal liberties, to be independent. Autonomy in the sense of the convention within the meaning of the CRPD means above all the freedom to take your own decisions, not even in particular then where support is needed. Autonomy in the sense of the convention is no longer to be excluded or narrowed down if I have a certain measure of reason. Or rather, where I don't come up with a certain measure of reason or health. Autonomy in the human rights model of disabilities means to have recognition and respect vis-à-vis decisions and attitudes that are not normality-like. Such understanding of autonomy is not really new. The women's movement, feminist theories have long uncovered that the idea of an autark person that in total isolation takes decisions is an illusion. No person will take important decisions alone or without decisions. If we marry, have children, buy a house, build a house or not, or have goose or fish at Christmas, if we apply for this or the other job, whether we take the one or other medical therapy, everywhere, all the time, we confer with people from our own social communities. That is, we accept support and help. The human rights model bans limiting the right to autonomy because of disability or even deprive it. The human rights model is based on the finding that human rights qua birth, qua being a human, are recognized and cannot be removed. That's why it's a fundamental error to assume an impairment or chronic disease could narrow down the human rights capacity. Also, the concept of solidarity has a new form through the CRPD. Social rights such as education, social security, work, participating in the community must not be made dependent on a certain functionality. They are human rights, and quasi being a person, being a human, they're allocated everybody. They're human rights and not welfare. As progressive human rights, they depend on the existence of sufficient resources. But they're only part of which we call the generally recognized catalogue of international human rights. A person who is granted social rights does not lose his status as a human this way. He must not, for the price of being granted social rights, be pushed into parallel or other worlds. A person that claims on social rights in particular shall not lose its rights to liberty. That, however, is the case in many countries. Policy for disability for disabled persons in many states is shaped by incapacitation kind of welfare. In many countries, it is social welfare at the price of deprivation of liberty, of being pushed into special areas, and forced treatment. On the other hand, the CRPD stands on solidarity, relying on autonomy and solidarity. We have to reconsider, in particular, where services are rendered. Let me address point number 3, the right to recognition as a person, as a human right. It's declared in the 1948 Human Rights Declaration, also the Civil Pact of 1966 knows in the Women's Rights Convention of 1979, does contain the right, that is the role model for the UN Convention on the Rights of Persons with Disabilities. The right to recognition, Article 12, not only affords that to people with disabilities, but also that was massively provided forward and progressed. The right to being recognized in law not only contains the right as being capable, but also being fit to act. For the lawyers amongst us, that makes a major difference. Not all legal systems know this distinction, but German law in particular does. And this distinction, in any case, has been set aside with the UN Convention. The UN requirement is both perspectives, both aspects must be considered. In the past, for many people, it was removed, that right, for slaves, women, people with or without and different citizenship, and people with disabilities. Article 12, paragraphs 1 and 2 clearly state that all people with disabilities shall be recognized as having legal capacity to act. That is part of human rights. It's an essential. The right to be recognized as a legal subject is one of the fundamental human rights, quite within what Hannah Arendt said, the right to have rights. Only where you're recognized as a legal subject can you claim on the entire catalogue of human rights. Where you have no legal capacity to act, you are sort of dead in civil sense. Civil death is the English term for it. Article 12, paragraph 3 has a further innovation and introduced the concept of assisted incapacity into international law. It says the contracting states take suitable measures to provide people with disabilities access to support that they need in exercising their legal and transactional capacity. This refers to two key elements of the human rights model of disability. One, autonomy and disability do not rule out one another, and those that do need support because of a handicap retains the right to act in autonomy. And secondly, the right to recognition as a person before the law is a right to equality. People with disability that need support for legal acts have the same right as non-disabled persons to take their own decisions in their lives, to conduct a life in line with their own ideas. This is, in our view, a clear no-go to the legal concept of incapacity to consent or legal incapacity to act because of a disability. Without legal construction, disabled people worldwide are and will, if they are cognitively impaired, be taken the right to subjective right. They are curtailed in it. The dichotomy between free will and unfree will in the context of impairment, in particular, is a fiction in most cases. Now, I'm not claiming that people with disabilities could not also be away from will and legally unfit to act. and being incapacitated. No, all people have such circumstances in their lives. As small children, when they're unconscious, when in coma, during sleep, possibly due to consumption of alcohol or drugs. But although no person is all the time cognitively up to standard, always awake, always fit to act, that is inviolable, although that is, the human right to recognition as a person is only denied certain people, or is curtailed for certain people only. And this, in today's time, includes children, in certain cultures, women, and virtually everywhere, people with disabilities. Where some impaired people, based on their health restrictions, are attested an unfree will, they're at the same time pushed onto a different legal track. Welfare support is granted through guardianship and betreuung, through being hospitalized in special institutions, or through forceful treatment because of psychiatric acts or other special laws. Marginalization, institutionalization, and forced treatment would never ever be accepted by people who are not marginalized. Their protective need is on the first legal track: consumer protection, emergency law, social security, protection under human rights. Overall is the autonomy as a result of human dignity, which is universally accepted on the surface, but actually is only afforded to those that fulfill a minimum of mainstream normality. Secretly, the prejudice of non-impediment applies for the full recognition of human rights. The underlying ideology for this form of discrimination is called ableism in disability studies. Ableism is comparable to racism or sexism, so comparable to forms of discrimination which rely on a dominance ideology. Ableism means that people are devalued. The people with disabilities, their life is deemed less valuable because they're suffering. Further, unfitness is ascribed to them and further differences, which seems to make it legitimate to refuse full enjoyment of human rights. Ableism can lead into animosities, but it may also, under the cover of welfare, show up. In any case, however, is ableism associated with the idea that people who are not disabled will know very sure what's good for those with disabilities. As an expression of the culture of dominance, ableism is the dominance of those that are not disabled against those who are. Ableism is reconcilable with the medical model of impairment, but not with the human rights model. Under the human rights model, it's not the unfitness, the incapacity that counts, but the capacity. I must jump. I get to point number 4, the implementation of Article 12, and in the law and in the practice. The implementation of Article 12, the right to like recognition before the law, contains, which the nation reports verifications show, the biggest challenge in the context of the implementation of the UN Convention. Although we have 166 ratifications on the way to universal acceptance of the Convention, the just under 50 state reviews show that most countries have major difficulties in the implementation of Article 12. Many states in their civil law have very outdated guardianship rules. There are countries where not even blind people or people without hearing may have bank accounts. We not rarely find laws where the institutional manager is the guardian of the inmates, etc. But there are also more modern betreuung laws, like in Germany, that bank on the replacing decision-making through representatives. We, at the expert committee, find for the CRPD that there are unclarities in many cases. Legislation, or rather jurisdiction, has shown that Article 12 demands the abolition of standard through supportive decision-making. The question is, well, where does it begin? Where does it begin? Where does representation begin? Where does support end? Another question is if representation and support with a view to Article 12, powers 3 and 4 are reconcilable at all. And then the key question, what happens if the will of the impaired person is not recognized or is directed at endangering himself or others? Is no representation possible then, in particular with a view to Article 4 of Article 12? The question is, what securities are necessary, as people need, to be supported to prevent them from abuse and exploitation? In the general comment on number 1 regarding Article 12, we responded validly regarding the question, not even every individual case, but we did say support and representation must not be pooled. They are not the same thing, and they must be clearly set apart from one another. And there are cases where representation is necessary, but also in those cases where the will of the individual cannot be communicated, not even with the strongest effort, cannot be spotted and identified. It is sure that the yardstick is not the objective welfare, but the will and the preference of the person concerned. And that must be identified with the best possible means. I'll jump further in my presentation to not take too much time from my successors, but in this context, I would wish to specifically address the general remark. General comment number 1 is the proper term, which is published on our website, which is very elaborative when it addresses the difficult questions. There are 9 key elements that a system of supported decision-making are made up by as against representation. I'll address the 9 key elements. I cannot dispense with them. All I can say, I can recommend to read them up. Furthermore, in the general remarks, we've laid down that the implementation of the rights are imminent duties. The right follows from Article 12. It is a civil citizen's right, so it's not subject to the reservation proviso or the consent proviso. In the general comment and in the guidelines for Article 14, we spelled out and we came out against any form of forced treatment. A gradual forced medical treatment for the purpose of treatment, this is shown in multiple modern studies, neither fulfill the purpose nor are they in line with law and of the state. Where forced treatment is used, that leads to further violation of the citizen's right. We highlighted that in our comment on the legislation and the jurisdiction. Article 12 and the human rights model, if you understand that right, you must logically ban forced medical treatment as a necessity in international law. And the expert committee knows in international law we're far apart from it. On this question, there are different perceptions within the various technical committees. Administrative judge suggested that. But that's not unusual in international human rights. In this field, this is shaped by what lawyers call leasing instruments. Like virtually no other legal sphere, international law, and in particular international human rights, is a developing field of law. Also, the Human Rights Commission in the beginning was isolated with its own legal perceptions. Looking at the jurisdiction over the past 4 decades, and you analyze that jurisdiction, you can find how the expert committees time and again contradicted one another, but they also inspired one another, they learned from one another. What legal opinions hold true internationally in the end, not least depends on the political, cultural, and economic relations. Civil society plays a mandatory role in this discourse. Human rights need to be visionary to kick off change. Social movements such as the women's or the disability movement are the driver of such change. such change that is backed up by expertise and academic research to be implemented in practice. The shift in paradigm to the human rights model of disability will not be made without abolition of the special systems, the legal special systems. We cannot go without abolition of that. The permanent thought and the legal concentration on exceptions, bracket, the example of the coma patient bracket, will not stop the necessary change in handling old people or adult people with disabilities. Modern psychiatric laws that contain certain elements of human rights are hardly implemented in practice. This is shown by empirical research. The reason for that is not just in lacking knowledge of the law. The system will only change once we close the back doors. Let me address at the end the question that I would like to ask, very briefly sketch. This is legal and practical problems. How are they solved when we do away without guardianship and Betreuung? I feel the solution can only exist in including those affected. Only if we have the perspective of everyone concerned in developing the law will we find adequate responses. This takes human rights-based participatory research, which in most countries has not truly been developed yet. In particular, this is true for the research of social and legal questions in the context of cognitive impairment, where participatory human rights-based approach is taken, astonishing developments may be ascertained, like under the auspices of Eleanor Frim from the Center for Galway, the Human Rights and Disability in the University in Ireland. The European project is carried on, where people are actively involved, who for decades were away in seclusion in institutions, who had forced psychiatric treatment, and who were deprived of their legal action. Voices is the project. It aims at legal reform in matters of legal capacity. The radical approach of Voices is that those people with disabilities are included in research and equipped with social science experts to have fundamental recommendations for the reform. One cognitively impaired person, or someone who's incapacitated or under guardianship, together with a legal or social science expert who knows the law of Betreuung. And these together, based on their experiences of those affected, develop ideas for the law, the reform of the law. In my academic career, it's one of the most intriguing research projects that I was ever involved in, and I'm positive we will come up with innovative responses once we're over after 3 years. But I'm also sure that at this Congress, we will have further other projects at this Congress who are exciting and will show us what way to go down in order to achieve innovation. And I thank you for your attention.